My name is John Carey. I'm the Executive Director of the Papua New Guinea Center for Judicial Excellence. We have a very exciting webinar for you, very compact with a lot of information to be presented. I'm going to have the pleasure of being your moderator today, as well as I have the pleasure of being able to introduce our presenter, Mr. Tim Prudhoe, who is a barrister and an attorney, barrister in the United Kingdom, England and Wales, and an attorney in the Turks and Caicos Islands in the Caribbean, has significant experience in offshore and onshore work. His public law work often involves him in proceedings adverse to governments on issues such as diverse as a refugee and asylum, to development planning, environmental protection, or enforcement issues. He's lived in the Turks and Caicos Islands in the Caribbean for quite some time. In fact, he's been practicing there since 2000 and also in the British Virgin Islands since 2004. His jurisdictions of admission and operation are Anguilla, Belize, Bermuda, British Virgin Islands, Dubai, England and Wales, Gibraltar, Grenada, Montserrat, St. Kitts and Nevis, St. Vincent and the Grenadines, Turks and Caicos, and Trinidad and Tobago. That's a mouthful. His trustee-related work has involved a major part of his practice. He's also a longtime fellow of the Chartered Institute of Arbitrators and an experienced arbitral advocate. His early pro bono work included death row appeals in Texas. There he worked on habeas corpus appeal issues for Stanley Falder, a native of Jasper, Alberta, Canada, denied rights under the Vienna Convention on Consular Relations for 15 years. He's done continuing pro bono work, which includes habeas corpus work in the Caribbean and a wide range of heavy crime at the appellate level. Tim has a LLB from Manchester University in the UK and an LLM from London University in the UK. He's admitted to the Gray's Inn and Lincoln's Inn. And so I'm very pleased to be able to introduce Mr. Tim Prudhoe to present on the topic Protection of Individual Liberty, Habeas Corpus Applications, Practice and Procedure, Successful Dealing with the United Nations High Commissioner for Refugees. Before I introduce Tim, I also want to say how excited we are to have a number of Chief Justices from the Pacific on the webinar as well, and we welcome all the Chief Justices from the Pacific Islands, as well as judges, magistrates, court staff, lawyers. Without further ado, Tim Prudhoe.
Yes, thank you very much, John. Esteemed attendees, John knows how long it takes to start things in the Caribbean. So if I could just say protocol having been confirmed and repeated, I'm very pleased to have the opportunity to present to you. I should just say I'm in a hotel in the Dominican Republic for work reasons. If you hear what sounds like a party anywhere outside of my room, it has nothing to do with me, but I obviously can't control the noise. As John said, I've had a relatively long experience with small islands, small jurisdictions, and also with the subject of habeas corpus. If I could just say to start with, I look on with great envy at the standard of IT that joins you all up. The Turks and Caicos is an archipelago of islands, and having a successful video conference with an island only 70 miles away is much more challenging than what I've witnessed here. So kudos to all of your IT folk, if I may say. So I'm going to share the screen so that you can see my slides. And there are many reasons why I am not an IT expert, but I hope I get this right. Hopefully you'll be able to see my slides, which you're going to be offered after I've finished today. And any of the materials that are referenced in the slides, you're very welcome to get in touch with me directly. So here I go. Right, you should be able to see the first slide now. And I'll also put my, my chat on if I can. I think we can take some questions as we go. Take them into the chat room if you'd like to give me them, and then I'll try and handle them at the end of the chat. So Let's make a start then. I should say that the habeas corpus work I did at the very beginning of my career in Texas was at the appellate level as a way of challenging the legitimacy of detention as a part of an appeal. That's a pretty different sort of habeas corpus, but was obviously with the stakes very high. So if I could just try and, there we are. Right. First of all, not everybody knows where the Turks and Caicos are, and you are in a very unusual audience in the sense that I think, as I'll come on to, many of the challenges that the scale of jurisdictions that you are involved in are faced by the Turks and Caicos and similar sized islands, and therefore some of the problems that I have encountered are likely to be directly relevant. So I'm hoping that the subject is not at all abstract, in fact, entirely the reverse. Turks and Caicos are about 500 miles away from the bottom of the US, and you'll see there that it is not very far from Haiti and the Dominican Republic. That's significant in the context of some of the work that I have been doing. Slightly zoomed out map, as it were, gives you an idea where it sits between North America, Central and South America. And a couple of the cases that I'm going to explain my involvement to you over involve both other parts of the Caribbean as well as South America. For a number of reasons, the Caribbean is considered to be a transit point for smuggled individuals into North America. Canada is the country that they tend to want to get to, and the Caribbean is described as being somewhat porous from a immigration enforcement perspective. The majority of the detainees that I have recently represented in the habeas corpus context came to the Caribbean via Cuba, then to Jamaica, then to Haiti, then to the Turks and Caicos on their way to Canada. And that was the end of, would you believe, a 2-year journey starting in Sri Lanka. And then recently I've represented, and I'm continuing to represent, a Syrian who came through to the Turks, also from Haiti, but his trip involved, or his journey involved South America at the bottom of this map. The Kajipan case is a case that really would be a useful case for you to receive from me after this, because it's an appeal that I won recently that has a whole bundle of these issues in the decision. And we have a very helpful, I can say very helpful now because it was in the minority in the Court of Appeal, dissenting decision, which discussed all of the points adverse to the way in which I raised the habeas corpus issues. So if you take one thing away from today, it's the citation to that case, which is easily accessible on LexisNexis, for example. But of course, I have a copy which I would be happy to provide to you. The slides, when you get them, have the links to those 3 articles below, all of which give a better explanation behind the very convoluted and complex facts for the habeas corpus cases that I was involved in. I have 16 Sri Lankan clients, and last year I brought 5 habeas corpuses for them, and we got them out on the 4th and 5th from detention that was deemed to be illegal. And in fact, I'm in court next week on another habeas corpus, which will be 8 for the last 18 months. Those first 2 web links are magazine articles in the main English legal journal for the bar, at least, that picked up the story about me and the Sri Lankans in the Turks and Caicos Islands. The individual behind the smuggling was a Sri Lankan and Canadian national who is now in jail in Florida, and that's just the Department of Justice press announcement. He was caught with 29 Sri Lankans, 16 of whom became my clients, and he charged them varying amounts of money, roughly about 50 to 60,000 US each, a huge amount of money for these Tamil Sri Lankans who had terrible stories of having sold not just their own assets, but borrowed from families and worse, borrowed from people who you really wouldn't want to owe money to be smuggled. So in addition to being at the other side of the world for a very long time, and they're now currently stuck in the Turks and Caicos with pending asylum applications, the very families who they were trying to help by getting to Canada, of course, now got to shoulder the economic burden of helping the relative who left. Some of them have gone home, thrown the towel in, as it were, to face pretty dreadful consequences, because leaving without permission in Sri Lanka is itself an offence. So they are very much going to have to go home to face the music. Chalaya, the smuggler, was the way I became involved. In fact, to start with, I represented him on his, what was likely to be an extradition effort by the US government. And generally in that part of the world, the one country that you do not want to be extradited to is the US. Their prison system and just the sheer amount of prison time that you're going to get is a different scale altogether compared to the islands. So he and I parted company because he felt he could do a better job on his own. So he went to prison first in the Turks and Caicos Islands, which really wasn't ever going to be his main concern. And then he was extradited. In fact, he waived extradition and went voluntarily back to Florida, and he's now serving a term of imprisonment there. Interestingly, several of the Sri Lankans were given witness immunity to testify against him in the US. That was the level of concern that the US government have about the route, if you will, through the Caribbean up into North America. So the Turks and Caicos look like that. That generally has a much greater impact when I'm not talking to people from beautiful Pacific Islands. Usually if I'm speaking to people from London when it's raining, everybody goes, "Oh, that's amazing." But I realize that the views that you have of the beach are like to be at least as good as that. And as John mentioned, I'm admitted in a number of these jurisdictions. So that's my background. One of the things that I would have appreciated at the time that I got involved in this work was some ready reckoners, easy reference type practitioner texts that I could have accessed straight away. A big concern for me, and a common concern for people who have language problems, the client, if you will, the applicant or putative applicant, who doesn't know what he's allowed to do. He doesn't know he has the right to challenge on a habeas corpus basis, is that they're not asking anybody to help them. A big problem in the Turks and Caicos was that there was no systematized method for even offering legal advice. So one of the things that I had to just worry about later, as it were, and I would really like to help someone avoid having to worry about it later, to be able to arm them with the information in advance, was my ability to bring a habeas petition for somebody who wasn't asking me to do that. And obviously, every lawyer knows that they have to have legal standing to be making any sort of application. But it just seemed wrong to me on a gut level, if you will, that somebody who was being kept in custody was deprived of the right to do this simply because they didn't understand their ability to do this. So the first textbook that I referenced there is a very digestible size. It's a relatively few hundred pages, and surprise, surprise, has an entire section on prisoners who want to make these sorts of applications, because the essence of habeas corpus is very often people are not in a position to assess their own ability or to understand their own rights to bring proceedings. So I was very relieved to find after the event that what I had started proceedings for was something that I was able to have started proceedings for. And there are a number of slave cases, in fact, about the fact that interested third parties who can demonstrate that a prisoner is being kept incommunicado, in the words of the cases, can have those interested third parties bring the application, so long as those interested third parties are A, in a position to prove that these people are being kept away from the help, and B, most importantly, under your rules, which I'll come to in just a moment, file evidence dealing with that. So we had to document our attempts to go and visit these people. And it was at a time when COVID had taken hold. So everybody was banned from the detention center, the immigration detention center, where these people were being held. And we weren't able to talk to them by telephone because they were Tamil speakers and we weren't Tamil speakers, and they couldn't speak any English. The main basis for the successful habeas corpuses in the end, and certainly the successful appeals, was that they were being detained not for immigration purposes really, but to help in the successful prosecution of the smuggler, which wasn't a proper reason for their detention under the relevant legislation. The second textbook there, which is an older textbook, is a study of habeas corpus over a much longer period of time and the sorts of situations that give rise to habeas corpus as available relief. And I say and it's a very interesting read. It's certainly not the thing that you would run to if you're just about to start and issue your first ever habeas application, but it is certainly very interesting. And the part in italics there, I would just flag up that and I'm aware of the sort of blended nature of the South Pacific and the jurisprudential influences. There are some heavy US influences. In the US, habeas corpus is much more recognizable as a basis for constitutional relief after an appellant's direct appeals have failed. It doesn't work that way in the English or common law jurisdictions. So the types of challenges that I was involved in Texas were much more to do with whether the effect of the consular relief being denied for the Canadian national, the first Canadian national to be executed in the States for 65 years when he was finally executed, was in effect a proper basis for successfully challenging his conviction and sentence to death. Just get to the next page. So I've done my best to do in advance of today, to do a bit of a review of your materials, because I'm very conscious that I'm talking to a number of jurisdictions, and where I've been able to successfully extract those materials, I'm going to refer to them. Some I haven't had so much success, and I understand that people have many other things to do than send materials to me. So I'm certainly not in any English way complaining. I'm just saying that I haven't seen everybody's procedural rules. And if people afterwards were to think that there was use in me seeing the rules, if they don't think I've seen enough of them, I'd be perfectly happy to tailor something like this more specifically to their jurisdiction. The good news is, and perhaps it's not that surprising, the good news is that they're very recognizably either English or American. The American ones I recognize from a bit longer ago than the English version, but many of your sets of rules, some of which are actually identical to the Turks and Caicos rules, are really a slightly old version of the English system. And that follows all sorts of obvious reasons. The point being, you have a very well-developed system for habeas corpus in most of the jurisdictions that I have been able to look at. The ones that I think are more challenging places to bring habeas petitions are the ones where your habeas relief is baked into your constitution rather than freestanding from that, reflected in procedural rules. Lawyers like an easy way to make an application. I don't mean on the merits, I mean an easy documented way. Certainly lawyers like me, need precedent forms to be able to use. And some of your jurisdictions have those. And I think, if I may say, be so bold as to say, some of you would benefit from having those. So the ones where I've said no, I only mean to, on that slide, I only mean to say that I wasn't successful in seeing your procedural rules in advance of today. Where I say not really, that's where I was able to find rules which I think are the right rules, but they're research of mine that hasn't been, as it were, signed off. So Fiji, for example, subject to me having found the correct rules, and I think I have, they have the 1988 English rules and the Turks and Caicos have the 1999. And for an application for habeas corpus, the rule hadn't changed. So it's right to say that my rules are Fiji's rules and vice versa. Habeas corpus existed in a variety of ways, but the one that everybody describes as habeas corpus now is the one that has the longer title there, and it's submit to scrutiny, really. It's a delivery of the body to the court for the court to decide whether the detention is legal. It's a detention legality test, and it reflects the fact that in the English system, many hundreds of years ago, as between separate courts, they often couldn't agree. So the senior court would issue a habeas corpus so that the junior court had to hand over the prisoner, and the prisoner would be taken to the senior court for an argument about who should be, if anybody, imprisoning that person. But the system that now exists became recognizable in about the 15th century, to say the least. The 15th, 16th, and 17th century was fairly tumultuous in English history. We had a period without a monarchy, but by the end of the 17th century, we had a recognizable statutory basis for modern habeas corpus. Amazingly, the modern world being what it is, you can find that on the internet, and that's the link to it. Or you can go and find it the way that I thought it would be interesting to do in advance of today. And I'll just show you that, if I can get to the next slide. Do it this way. That's Lincoln's Inn Library, in case anybody wants to know, and that's in central London. And just to give you an idea of the size of the original legislation tome, it's the printed copy on an A4 basis is sitting on top of the book that I got the original legislation out of. It's amazing that it still exists, but it is. And they, as you probably know, they categorize it by the year of the reign of the monarch. So there it is, bottom left-hand corner is the first part in the original copy of the 1679 habeas corpus legislation. So I'm having to move my windows around on my laptop, I beg your pardon. So these are the various frameworks. Order 54 under my rules and Turks and Caicos rules are simply the pre-Wolf Reform White Book rules. Volume 1 of the 1999 White Book are you'll see there, number 2, Fiji, also Order 54, Rule 1. And the others all have procedural rules which track making an application, and they are recognizably similar to Order 54. Pilau, I have a question mark there only because the kind soul who sent me a couple of extracts, I couldn't tell, I was sent 2 extracts, I couldn't tell which was which, but I know, and because I have seen Pilau have a procedural mechanism for making an application. Samoa and Vanuatu have a constitution-based application process, which is better than not having an applications process at all, but not as easy to navigate for a lawyer in a hurry. And usually habeas corpus applications, by their very definition, are made in a hurry. And perhaps some backfill, if you will, on procedural rules would be a really good idea there. And I say perhaps in relation to the Cook Islands and Tonga because I've seen what I think is the material, but I've only found reference to Order 41 for Tonga in a case I found on the Pacific Legal Information website, which is terrific, by the way, far, far better than anything I have access to. So another thing for your community to be very grateful for. I could spend many hours on that material. And the Cook Islands do have statute for it, but I wasn't able to find anything more specific than the statute. So this is the statutory provision in the Cook Islands, which demonstrates, as you'll see, that it exists. You'll probably guess from the font that that's a relatively old piece of statute. Nothing much looks like that anymore, but it's great to see. And I wasn't able to drill down successfully to find what supports that from a procedural perspective. These applications, in my experience, have the judiciary taking a very pragmatic view. If you've got the documents slightly wrong, you're not going to be sent away, other than perhaps being asked to give an undertaking to fix it so that they can get on and make the decision in substance. So my experience has always been with the judiciary that they want to get to the end of the process as promptly as is appropriately possible as well. But equally, it's good to get the materials right. Kudos or gold star to the Federated States of Micronesia, and if I could specifically mention Craig Raffner, who a staff attorney there, who was prepared to sit down and lead me through their electronic resources. They have what I would call a primer, a digest document, and this is simply an extract from the digest document, which obviously I had a specific reason as to why I wanted to educate myself a little bit more about the materials. But what a fantastic resource for someone, whether it's someone in the legal profession or a member of the public trying to educate themselves about whether they or someone they're interested in wants to bring an application like this, to have this level of material available to them. I mean, that certainly outstrips anything in the Caribbean region in terms of what's available relatively easily on the internet to access. And I should say that that's a small part of a larger document, but I thought it encapsulated very neatly how much information it provides. So to get to the nub of it, it's usually a two-stage process to make an application. And forgive me, I'm aware that I'm in very august company. So forgive me for those for whom this is information that's really not very novel to them. It's a permission application, which has various names, but it's a permission application, a first look, if you will, at whether or not your underlying reasons for the writ are sustainable. And then there's the hearing of the writ itself. In the United Kingdom, in England and Wales, usually those are now heard together, and habeas corpus has in large degree being replaced in the United Kingdom by judicial review. So habeas corpus as a relief in England and Wales is much less prevalent than it once was. When I say the United Kingdom, of course, I should really make clear I mean England and Wales, because Scotland has a separate, much more continental legal system. So the application, I'll deal firstly with the permission stage, or stage one. It's the equivalent of what the American-influenced jurisdictions here today, Micronesia and the Marshall Islands, would call the show cause orders. It's the first stage, and it can be an application that's made ex parte. Ex parte, for people who have not had to suffer the Latin, just means without the other side being around. It doesn't have to be, and of course, even if you make it ex parte, as I'm sure you realize, a judge might not be happy with that and may demand it to be heard with the other side being given notice, which is in effect the show cause orders mechanism for FSM and the Marshall Islands. Very similar concept. I much prefer to make the application on short notice, so that the suggestion that you have failed to disclose anything material at the hearing of the writ. Anybody saying that you shouldn't have got the writ issued because you deliberately concealed X or Y is a much more difficult allegation to make if you've had the other side there. Of course, it's a bit cheeky because short notice often means that they don't really have a full grip on the facts, but you tie their hands to a certain degree in them accusing you after the event of non-disclosure. I started, when I was struggling for a basis to bring an application on behalf of a prisoner, as I mentioned, and was worried about that, I made my applications on short notice so that if they wanted to complain about that, we could air it at the beginning, and that nobody wanted to accuse me later, or nobody had a proper basis to accuse me later of doing something for which I had no sufficient legal standing. The big problem that we had is that we couldn't get the clients. So it was a bit chicken and egg. We couldn't bring an application because we couldn't get to the clients. We couldn't get to the clients because we couldn't bring an application. It was a circular position to be in. But in fact, we turned that around and used it against the government, and all of the emergency regulations that had been brought in to shut the detention centre down for COVID. I'm not suggesting that they weren't for bona fide reasons, but for COVID related reasons, we used as part of the evidence to demonstrate that these people were being kept incommunicado. And we had an additional layer, if you will, of proof that they needed a third party to act for them because they couldn't speak any English. The other thing that it's important to get right, but of course you can amend a writ of habeas corpus, is on the notice of motion application, so the permission stage, stage one, you're going to have to be ready with a draft writ, and you're going to have to be able to articulate who you think is detaining these people. In the Turks and Caicos, and in many other jurisdictions in the Caribbean region at least, you also need, whenever you bring proceedings against a government official, to make the Attorney General a party. It's under the Crown Proceedings Ordinance in the Turks and Caicos. So you knew that that person was going to be the defendant, but she, our Attorney General, is only a nominal defendant, really. She has to have notice of the proceedings. The actual respondent was the Director of Immigration. Why was he the respondent? Because he controlled who lived in the immigration detention centre. So he was, in effect, the jailer, which is why in prison habeas in the UK, it will be the governor of the prison. I'll come on to one of those cases in just a second. So the big thing in a detention case, particularly if you have, as every country is likely to have at the moment, COVID-related practical impediments, is whether or not the planning continues to repatriate somebody. So if, as the Turks and Caicos had, they had a large number of detained illegal immigrants about whom there was no dispute that they had arrived illegally, and if the government's official line was that arrangements were being made to repatriate those individuals, but the world had closed, as it were, the question then becomes whether there was a continued intention to remove them and whether everything that was viable was being done. The big problem that the Turks and Caicos government created for themselves is they didn't document anything. So they would assert in court that they had been in constant communication with various governments to try and get the Sri Lankans back to Sri Lanka. But they had no proper documentation by which to demonstrate that. And their other problem was that a number of these individuals had refused to sign voluntary repatriation forms, which meant that they were intending to apply for asylum. Well, as soon as somebody has indicated an intention to apply for asylum, and this is really important, they no longer allow the government that is detaining them to claim a continued intention to remove. So it would be what habeas corpus lawyers would call a Hardial Singh failure. you can't satisfy the case of Hardial Singh, which said in the mid-1980s that if a government is doing its best and everything is heading in the direction of a repatriation, the continued detention is justified. And nobody in the Turks and Caicos government was stress testing, as it were, their efforts against that analysis. And their real Achilles heel was that a number of these people had refused to sign the return forms, the voluntary repatriation forms, so you couldn't even run a Hardial Singh argument. I couldn't prove, but had my suspicions about everybody else's form indicating, first of all, that they didn't want a lawyer, and secondly, that they wanted to be repatriated on a voluntary basis. Every single one of them was signed within 20 minutes of each other, 3 days after I'd issued my first habeas corpus writ. So it was impossible for me to prove it, but I think even the judiciary, the court, was skeptical as to the bona fides of the penny had dropped. There was no documented evidence of even an offer for legal advice or access to lawyers. Not the same thing, because there's no constitutional guarantee in the Turks and Caicos of paid legal advice, but access to legal advice at all. So taking it from the other perspective, if one was advising the government, and I'm obviously not, but if one was advising the government, the first thing that they would need to have in their sights to satisfy would be the Hardial Singh requirements. And if anybody would like a copy of that case, it's really the case now in habeas corpus. I'd be happy to provide that through the centre. Where I say check your draft order, so you successfully get your release. In the Turks and Caicos, we have a system of the applicant party having to provide a form of order which gets agreed by the opposition, and if you can't agree, you go back to court, but usually it gets signed off. I recently brought a habeas petition, not for any of the Sri Lankans, but for a Syrian, and he was preemptively released. So I issued my application for stage 1. I had a court date for stage 1, and they pulled the rug from under me by announcing at the hearing of that application that they were going to release on a voluntary basis. And they ran the Hardial Singh argument, saying that they were busy looking for accommodation. When they released him, and so the order for the writ, the order was, in fact, if he isn't released by, and there was a time and a date very soon after that hearing, a writ would run. But we didn't specify in that order, because we didn't think that we needed to, that there should be no conditions attached to the release from unlawful detention. So the order was made, and then he was released. And then it turned out that his release documents had a long list of conditions. So no one had talked to us about those conditions, but the government had imposed conditions on his release. You can't do that. So if you're a detaining government and you're detaining someone unlawfully, guess what? You don't get to attach conditions to a release from unlawful detention. And there's a UK Supreme Court, and UK Supreme Court, for anybody who might not know, is the renamed House of Lords. So it's our highest level of appellate court in England and Wales. They've made that very point in a 2018 case. If you are illegally detaining, that person gets out without conditions. So what happened in the habeas corpus that I had won, but it had ended with conditions being attached to this Syrian's release, is that I immediately said, these are unlawful conditions, issue the writ, because it's not a proper release. The court declined to issue the writ because they didn't agree with me. So in fact, what is listed there as CL31 is that should be a 2021 case, I apologize, is the second writ of habeas corpus. And we have this bizarre situation where Moin al-Hashash is actually out of detention, but there is an argument about him being in what is called in the cases qualitative detention. So there are so many conditions to his release, which we say shouldn't have been added, that he is detained on a quality of life basis, and that's for hearing on Tuesday of next week. So the point is, if you're in that situation and you're suspicious of what the government is going to do, make sure that your order expressly states that there will be no conditions, or if there are going to be conditions, that it lists them. For example, in the Turks and Caicos, it's illegal for anybody who's not a Turks and Caicos Islander to work without some sort of immigration permission. So there's nothing that you can do about that for anybody. That sort of condition is something that exists elsewhere in the law, but this person has to report very regularly, he has to live in a certain place. It's as if they granted him bail and they had no power to do that, or at least that's the issue that's yet to be decided. So that's a little bit about the habeas corpus process. Parallel to that, and something that I would be hopeful to try and help others navigate some of the mistakes that I have made over the last 12 months, is the dealing with the UNHCR, the High Commissioner of the UN for Refugees. Naively, 18 months ago, I had a fairly idealized view of the UN and felt that they would be very much on the side of the candidate refugee. I'm a little bit more jaundiced about that now. Just to explain the difference between refugee and asylum seeker, so that you have it fixed in your mind. A refugee is an international concept. A refugee is somebody who is deserving of protection under the standards of the 1951 Convention and its 1967 Protocol. An asylum seeker, on the other hand, is an applicant in a country. So you can be a refugee anywhere. You can be a traveling refugee, but you can only be an asylum seeker in a particular place. So, for example, in the Turks and Caicos context, these Sri Lankans, some of them became designated refugees, but they only become asylum seekers when they put in an application to the local domestic government. And becoming a refugee helps your asylum application because it's a designated status, but it doesn't decide your asylum application. It's a useful step on the way. Now, I'm aware from research I've done for today that there's a difference across the jurisdictions represented today as to who is a contracting state under the convention and who has refugee-specific national legislation. In actual fact, it's not really determinative of anything having the national legislation, because Turks itself demonstrated that they have their own domestic process for assessing asylum applicants. But in fact, what they did is they back-officed it, as it were, contracted it out, the analysis, to the UNHCR. And that's how I first became involved with the UNHCR, because the Sri Lankans that I was helping had their claim to refugee status, their circumstances, if you like, assessed by the UNHCR. And that involves a refugee status designation process. And that's a term of art, that's a technical phrase that the UN throw around, an RSD. And if you use if you have to deal with the UNHCR and you use the phrase RSD, they'll know right away that you have got some of the research done already. And it's very important to understand that and lawyers are very arrogant sometimes. We think that people will let us attend meetings and they'll let us participate just because of our qualification. They were unwilling to let anybody from my firm, including me, attend any of the interactions between our clients and the UNHCR. So just say that again. It still amazes me the UNHCR were given a role by the Turks and Caicos government to assess the refugee status of specific Sri Lankans, and in fact I have a Syrian gentleman now, as I mentioned, who they knew were our clients, and they refused to let us be at the interviews. These are fact-finding interviews, added to which we had a mountain of material from the criminal investigations, because these people were each interviewed in the criminal context to help prosecute this smuggler. So we were in the weird position of providing to the UNHCR for their interviews that they would not let us attend information about the individual clients that we obviously knew more about than the UNHCR. The frustrating thing was that they would let an immigration officer from the Turks and Caicos Islands attend. So I documented having a colleague of mine turn up to each of the interviews to be refused, so that we could demonstrate, not just for our own records, but also for any asylum appeals, and also to the clients who thought we had forsaken them. Imagine clients asking you, why are you not at these interviews? It was real heartrending stuff. But the takeaway, as Americans might say, the learning tool for today is that on that link there, which says Learn Connect, that's the route into the learning materials for the UNHCR, which they said at the time, had we trained ourselves sufficiently to convince them that we were good enough, as it were, in immigration work, they would have let us sit in. I don't accept that that's what would have happened. I think they were just setting us up because there was a long enough gap between interviews for us to say, give us the materials and we'll have somebody at the office study them so that they can be at these interviews. And in fact, their next line of defense, as it were, was to say that there were no courses on offer and they'd be back in touch with us when there were. So if there was any part of any of the jurisdictions attending today who wanted to have the capacity to participate in those RSD interviews, don't make the mistake that we accidentally made. We didn't know anything about this training until we were told it was the reason that we couldn't sit in on the interviews. Get that training done. It would make all of the difference. The RSD interviews produce 13, 14-page document assessing that individual's need for designation as a refugee. And the reason that we know that the reports are of that sort of size and very detailed is because amongst the variety of proceedings that we had to start against the Turks and Caicos government, there was a set of proceedings to injunct, to get an injunction to prevent deportations, summary deportations for 3 individuals, and those judicial review proceedings were settled on the basis that the attempts were abandoned, and we got those 3 reports. So they were the first 3 people to have reports written about them, and we got to see the reports. The reports are only about those individuals, and all hell broke loose once we got those reports, because it turned out that the Turks and Caicos government shouldn't have given us those reports. So even though they were purely about our clients and specifically dealt with the fact that these individuals were deserving of refugee status, we were apparently not supposed to have received them. More surprising than that is when we got the inevitable asylum rejections for those 3 people, and we compared them to the RSD reports, which recommended refugee status and granted refugee status, they were cut and paste jobs in the ministerial refusal for these people's asylum. They took vast tracts of these reports and reused them. We used that methodology in a separate judicial review to try and get the RSD reports for the other 13. And we were refused those reports that's a current appeal at the moment. We refuse them on the basis that they were privileged and confidential as between the Turks government and the UNHCR. Well, that makes no sense to me still, and I hope it makes no sense to the Court of Appeal, because how could it be privileged against the subject of that report? The point for the audience today, though, is that although those designations are absolutely key to the prospects of one of those people making a successful asylum applications, expect the UNHCR to ignore your requests to see those reports. I certainly hope that the appeal that we have pending will bring some clarity. I think it's nonsense that these people don't get to see the reports on themselves. And the icing on the cake, as it were, for that argument is that we have 3 examples of how relevant those reports are to the asylum determination. So watch that space, in a sense. I think we're almost at the end, close to time. Yes, those are my contact details. And again, a photograph with slightly less impact for people who live in such a beautiful part of the world as you folks. But I would be more than happy for people to ask me questions either now or after the event for any of the materials that I've provided. So I don't know, John, if we have any time. I've not left very much time, I'm afraid, for questions if people have them.
I think we have a few minutes for questions, if there are questions.
Okay.
If there are questions, feel free to unmute. I believe you should be able to unmute your mic if you do have questions.
It seems possibly not. If people would prefer, for whatever reason, to ask me them offline, as it were, I'm very happy to deal with that. And as I say, I'm very happy to provide any of the materials out of this that you may think are relevant, including I have, of course, PDF copies of the convention, PDF copies of the protocol. I'm very happy to provide skeleton arguments for the parts that I think were absolute nonsense about these documents being privileged against the clients.
Tim, Judge Gate from Papua New Guinea.
Okay,
Yes.
Justice Gator, yes.
Yes. For courts, what types of orders can courts issue in habeas corpus applications, and have there been any refusals?
Yes, there have. The usual order would be for immediate release. The slightly more nuanced order in a jurisdiction, obviously the Turks is really what I know the most about. The problem in the Turks with the usual order was that these people had nowhere to go and nowhere to live. And so the order was, it wasn't suspended in the legal sense, but it was to take effect. I think it was 48 hours later, because accommodation had been organized, but not by then paid for. I had several of my applications refused, and the circumstances of the last refusals, apart from the slightly odd one that I described about the conditions and then the court refusing to issue the writ, but I had a writ refused when in the middle of, well, it was habeas 3 or 4, in the middle of that habeas, the government surrendered, as it were, and I knew that for those 5 people, an order was going to be made, and it was made. In that hearing, the government indicated that another dozen or so, some of whom weren't my clients, were also going to be released. I still sought orders, I still sought writs on those others, and the court refused to issue them because of what had been said by in the other proceedings by the government. So I suppose you might say the faith that the court had in the government to do the right thing by the others was the reason for the refusal.
Yes, I'm just wondering.
Sorry.
Sorry, go on.
Well, what I was going to say, I didn't mean to cut across you, I'm sorry, was that at the beginning of all of this, having been at the first hearing on what I described as short notice, so they were there, but they were perhaps slightly taken by surprise and had not raised the question of standing. On the return of that writ, they challenged my ability to make the application at all for the reasons of standing. And they arrived at court with disclaimers, in effect. So this Sri Lankan, who really didn't understand a word of what was going on, had been made to write out in what I can only describe, no discourtesy to him, as sort of pidgin English, broken English. I like prison. I like here. I don't want a lawyer. And obviously it wasn't a situation where you could laugh at that document, but the judge and I mean, certainly eyes were rolled because it was so blatantly manufactured. And anyway, the judge accepted the argument that I had made that the ship had sailed, the writ had issued, and the standing issue was something that decided whether the writ issued. Now that the writ is there, how it happened is not material. The court has a job to do, and he accepted that argument.
Really? Thank you.
Hey, Tim.
Yes.
This is Craig from,
Hi.
we spoke a few days ago. How are
Yes,
you?
I'm fine, thank you. Thank you again for your help.
Yeah, no problem. Thank you for the kind words. I don't really have a question, but I was just going to add some comments. One, and it was an experience that we had here in the FSM. You said that a lot of times the advocate and the client don't really get a chance to work together before the application for the writ is filed. We had a situation here where a person who was purportedly being detained was summoned to the court, took the witness stand, and actually said that they had never met their lawyer and didn't know who she was. And she was in the courtroom.
Yeah.
So, and then the second comment I was going to offer to you, and it's something that started happening here. And, you know, for those of you who don't know how the FSM is organized, we're modeled after the United States. So we have 4 states that run fairly independently with their own judiciary, and then we have a federal level. That's where I am. We've had a couple of applications for habeas corpus, and the situation is that someone's being prosecuted in state court, and they're still ironing out issues with the bail. And a lot of times the attorney will jump the gun and come up here to the federal court and try to convince us that the person's being unconstitutionally detained.
Yeah.
And, you know, we kind of take a hands-off approach with that, and at least until the state court makes an announcement on what the terms of bail are. Because we can't really get involved and second guess a state court judge who clearly has jurisdiction and authority to prosecute the criminal case.
One of the,
So I just,
yeah.
Go ahead, Tim.
Well, no, I think yours is a very interesting constitutional arrangement, and I understand why your court would need to be quite hands-off with the trial court, if I could call it that. My jurisdiction is a good deal smaller, and to be blunt about it, a good deal less sophisticated. And what happens with, outside really of a sort of purely criminal defendant, but more a person who's a criminal defendant because they are an illegal immigrant, what happens is that they get to the end of what might be a relatively short prison sentence. Often by the time that they end up for sentence, it's a time served sentence, which of course, as you know, is you get out, you just signed off and you get out. But there's nothing ready for these people so that they're taken back to custody. And what is the status of someone in that situation? Nobody's looked beyond their nose end, if you forgive the English expression. No one has thought, well, on Tuesday, this illegal immigrant will have finished his criminal sentence. What are we going to do? And in fact, the Syrian case came to me because the sentencing magistrate watched the police take him back to custody and asked me to get involved. He said, "What are you doing? This man can't be detained. I've just sentenced him to a time-served sentence." Well, we don't know what else to do. So part of the growth, I think, in habeas around the question of illegal immigration is a lack of planning. No one has any sort of forward thinking about what happens after these people have been punished, as it were. And the reason in the Turks that we have such a chronic problem for the lack of planning is until recently, most of our illegal immigration has been Haiti. And everybody in the region and many beyond know the problems that Haiti faces. But Haiti is very close to the Turks. So what happens is these people get picked up in boats, they serve X number of weeks for illegal entry, and then they're taken straight back that day when they're released. Well, you can't do that with a Syrian or a Sri Lankan or wherever else people may be arriving from a terrible place that they're going to claim asylum from. So it's a resource issue, made all the more interesting by the fact that places like the Turks and Caicos have this constitutional relationship and dependency on the British government. So they're spending British money, and there's a time delay in getting direction as to what to do next.
Anyhow, it's Craig again. I want to thank you for everything you did. A great presentation. And I hope we see more of you out here in the Pacific.
Well, I'm a big fan of small islands, as John knows. So yes, I would love that. When the world is a bit more normal, perhaps.
I think we have reached our time limit. We tried to keep within the 1 hour, and Tim and the audience, everybody has done well. We're a little bit over. So at this point, I'm going to hand over to Stacy before I give closing remarks.
Thank you. I'd like to extend our gratitude to Tim Prudhoe for giving us your time today to facilitate this webinar and for all your valuable insight on habeas corpus. I'm sure everyone today has a far more better understanding on the practice and procedure applications, and also dealing with the UN High Commissioner for Refugees. I would also like to take this opportunity to thank the chairman of the board of the PNG Centre for Judicial Excellence and the Pacific Island Countries Centre for Judicial Excellence, which is the Chief Justice of Papua New Guinea, Sir Gibbs Salika, the management and their team for arranging that and hosting this first ever webinar session for 2021. I would also like to acknowledge the participation of all the judges and the magistrates in the Pacific region. Lastly, thank you to you all participants who are able to join with us today in this webinar, and I look forward to connecting with you for some more webinar sessions and more training workshops in the not too distant future. Thank you.
Thank you, Stacy. And just for the benefit of the audience, Stacy Lavakiowali is a program officer for the PIC CJE, and she is responsible for organizing judicial education and training for Pacific Islands, particularly for the judicial officers and at this time court officers as well. I just want to also advise that we will be sending a list of all of the webinars we have planned over the next 6 months so that we give you enough time to make determinations on which ones you wish to attend. I can see, just looking at the screen, Chief Justice Lunabek from Vanuatu and Chief Justice Palma from Solomon Islands. We appreciate you taking your time. You're very busy to engage with us as far as observing. And to all the other judges, magistrates, court staff, and lawyers, thank you for being with us. We wish you well. For those of you in the afternoon, as you wrap up, have a great weekend. Tim, I think it's night, so get some rest. And
Thank you, Will. Thank you all. Thank you for the opportunity.
Good day, everybody.
Thanks. Good night.